us turned. So hello and welcome to this session today on legal matters. This particular workshop, oh, what we're going on here? Let me change the view. This particular workshop is going to be covered, get this, by my actual business protection lawyer. Helen Kay is the founder of Rise Legal, an Australian-based law firm who focus predominantly on legal protection. This is helping you make sure that things that are easily preventable don't go wrong, or at least you have the maximum protection in place to protect you from the worst happening. So this can cover a whole variety of things, as Helen will cover today. But some of the things that I do for business protection, thanks to having Helen on my side and having my back, it could be anything, guys, from your contracts, your agreements, your staffing, IP protection, copyright, trademarking, a whole bunch of different things that are really important to keep your business and your assets protected. Helen's going to be covering today 5 critical things that every single business owner of every kind of size and industry absolutely must have in place if you want to have the maximum possible protection for things going disastrously wrong in your business. So I'm going to hand over to Helen, my amazing lawyer, who has so kindly given us her time for free today. And FYI, she does have an absolutely mad offer that is just, it even blown my mind. And just to not hide anything or do that growth webinar thing where it's like, wait till the end for the sale, I'm going to literally drop the link in the comments right now for you guys to check out. She's got a really cool deal for packaging up your terms, conditions, as a course creator. She has specifically made this package for you guys as course creators, and it covers some of the things that she's done for me. So I'm going to drop that straight in there. It's an incredibly insane offer. It's only available at the price listed on that page for the next 24 hours. After 24 hours time, it will go up to its full price. However, I'm not going to go in here and do a sales pitch. Introducing Helen Kay from Rise Legal. Hey, Helen.
Hey, how are you?
Awesome. Thank you so much. I know you've got a deck of slides to show us here. So first of all, thank you for all the work that you've done for us at Techmatics and on my course creation side as well. This is going to be an amazing opportunity for people in all industries to take away some tips for getting themselves protected. So Helen, I'm going to hand the reins over to you, and also I'm going to unpin myself and put you now in full control with my mic off.
Okay, amazing. Thank you. Thank you, everyone. So yeah, I'm Helen Kay. I own a small business protection law firm here on the Gold Coast called Rise Legal. I'm very fortunate to have Sarah as one of my amazing clients, which is great. We're very picky about who we do work with. So yeah, it's great to work with somebody like Sarah who sees the importance of business protection, because it is very, very important. So what I'll do, I'm going to be covering a lot today. Now, I've seen Sarah's presentation, so I know that Sarah goes quickly through things. So I'm sure you're going to be really, really all over the English accent, as well as the speed and the amount of information thrown at you. So I'm going to jump in now and share my screen with you all. Just give me a second. Okay, share screen. There we go. Share screen. This one, share. So hopefully Sarah will give me the thumbs up if that has shared my PowerPoint slide. Okay, so you can see here what we're going to be covering. Exactly as we said in the marketing, the 5 critical legal risks that business owners must avoid. So as commercial lawyers, we see these things time and time again. It's a pattern. It's a pattern that businesses do not look at these things proactively. So I'm going to give you lots of free tips today for you to jot down and go and see. If you're not in Australia, then take these notes, go and see a local attorney and go and speak to them and say, these are the things I want to cover. And, you know, hopefully they can jump on and do similar sort of magic like we can do. So what we're going to cover today is with those top 5 mistakes. At the end of today, you're going to understand what you need to do to make sure that you get paid, which is what we're all in it for. I think, you know, we all have a purpose, but we want to get paid for what we do. We want to limit our liability. There is no point going out there and having all this unlimited liability and putting yourself and your families and your assets at risk. What you need to do to protect your really valuable intellectual property, and that's everything that you've taken from here and popped into some form, a video, a workshop, a how-to, all of that's your intellectual property. We want to protect that. We want to tighten your arrangement with any contractors. And we also want to make sure that you've got the right business structure. So what we're going to do is we're going to do a little quiz at the beginning. So I know Sarah loves her quizzes. We're going to do a little quiz and you're all going to get a result so that you all know going into this, am I fine? Am I low risk, medium risk, or high risk? And you know then which bits that you are a high risk in. So first of all, just to put me into a category, as it were, I do a lot of presenting. So I do, like Sarah does, on stages, at conferences, that kind of thing. Now, sometimes I see a glazed look in people's eyes because they're thinking to themselves, and I can guarantee they're thinking, I don't need a lawyer. I'm not in any pain point at the moment. In other words, nobody's trying to sue me, and I'm not trying to sue anybody else. Everything's fine. I don't have any legal issues. Well, that's not where I come in. I'm what we call new law. So Rise Legal is a new law firm. So what that means is, and you can see on that table, I've tried to draw the distinction with traditional law. So traditional law is very reactive. So what happens is, someone might serve on you, a statutory demand to appear in court, and you're going to need to find one of those really scary litigators to help you. So we don't do any of that. We make sure that our clients never fall on that side of the line. I always like to liken it to the healthcare sector. So in the healthcare sector, you've got your heart surgeons. So these are the people who jump in when you're in pain, you've had a heart attack or you're about to have a heart attack and they need to do something quickly, and you need to go and see that specialist because things have got to that point where there's no other alternative. The heart surgeon in the legal world is that litigator, that person who goes to court to help you when you're in that pain point. Now, in the health world, I'd like to think of us as the dietitian and the personal trainer. We're the ones that will prevent you through some good practices and some simple habits and behaviors from getting to here. And this one, as you can see from that slide, costs 16 times less on average than getting yourself over to here by burying your head and thinking, I don't need a lawyer. Every successful business needs a really great business coach, a really great accountant, and a really great lawyer just on their team, ready for them to know what strategies they need to put in place. So just as a law firm generally, I know there's a lot of issues with law firms who bill for every 6 minutes. So if you're too scared to pick up the phone, they're going to bill me, too scared to email and ask a question. New law firms like Rise Legal, and there are others like us, have transparent fixed fee pricing. So it's really easy to pick up the phone and call us, and we will quote you and we'll give you a price. So again, just thinking of it, just putting it in that actual context where you need to be proactive about your legals, understand your risks, have a plan, and that is affordable and it provides you with peace of mind. So just getting rid of any of these preconceptions about I don't need to listen because I don't need a lawyer. Everybody who wants to stay in business and thrive in business needs a really fabulous business lawyer on their team. So now I will jump in with this, the quiz. So if all of you, I know normally we all tell you to put your phones away, put them on silent. I'm going to go against that norm now, like Sarah does. And I really want you to jump in and find out by using this Q code. And it is a 2-minute quiz. It's going to ask you a couple of very simple yes or no questions. Now, everybody who does this quiz, obviously, if you put your email address in quickly, you will go into a list. I have a lovely secret prize that I'm going to give out, and it's a pack with website terms of use and a privacy policy. So I will randomly, using a random generator, will pick a winner. So, but aside from the gimmick, this is really helpful for you to know going into this presentation now, whether you're watching it live or whether you are on a recording, and we'll do the prize in 24 hours time to catch all the people who listen to the recordings as well. It will help you know where your risks sit in these 5 key areas. So I'll leave the Q code on. Is anyone having any difficulties? Maybe let Sarah know, and Sarah could jump in and let me know.
Drop in the chat. This is an awesome quiz, guys. I've obviously done this myself already, and it's really, really fascinating to see where the giant holes in your risk is in your business. Believe me, as somebody who has been there, done this for 15 years, you think you're all good, I'm a good person, nothing's going to happen to me. Unfortunately, it's not always about how you operate, and no matter how good you are and how kind you are and how ethical you are, Unfortunately, if you don't have these protections in place, there will be a day in business where you do find yourself falling through one of these holes, and that is a very expensive situation to be in. I have a lawyer so that I don't need a lawyer, if that makes sense. And this is what Helen does for me, is she basically makes sure that I have the biggest protective shield built around me, so that, you know, if the proverbial stuff does get thrown my direction, it bounces off the shield and we stand protected and strong, and never needing to find criminal lawyers or lawyers that will end up, you know, having to go with me to go to court and so on. You know, Helen's job is to stand there in front of all of that and make sure that that never happens in the first place, as far as reasonably possible, of course. So if you use your camera to scan this hardware, if you're using an Android, pull your finger down from the top of your Android home screen to the bottom, and you'll bring up your settings, and there should be a QR code scanner. Otherwise, the normal camera on your actual phone that you would take a photo with will often open a link on a QR code just from using your normal camera.
Amazing. It shouldn't take a second. I mean, maybe people could give a thumbs up when they've finished it, and you'll get a risk rating. It's very, very rare that you'll get a low risk rating, unless you say maybe someone like Sarah, who's been through a few things with us. You'll get a low risk rating now, Sarah, because we've addressed a lot of the things that I'm going to talk about today.
Yeah, Helen, can I just jump in there? Carol's saying that it's the thing that she's got's requiring credit card information. It shouldn't require a credit card.
No.
No. There's no credit cards that you need to put into that at all. It's a completely free assessment.
You've probably gone on to the link for the really great offer that Sarah popped in the chat, rather than this free quiz here, which is a different thing.
I'm just going to see if there's a direct link to this that then I can put in the chat for those people who are having trouble scanning.
It should be, yeah. It's sat on a page somewhere.
Cool.
And people can do this while I'm talking, to be honest. Like,
yeah, I'm going to drop this link directly in the chat box, guys, so that Helen can move. If you want to carry on from there, Helen, I'll drop the direct link in the chat to this.
Amazing. Great. Okay, great. So what that quiz did was it went through what I've identified in the last 25 years of legal practice across, you know, Australia and the UK as being the 5 top risks, which sit in those areas of your structure, your intellectual property protection, how well you're protected with your clients, how well you're protected with anyone you partner in business with, and how well you protect yourself with your suppliers. So I'm going to drill into each of these things. So I guess some are going to be more exciting for you to listen to. There's going to be something you should be able to take away from each of these 5 risks. So again, as commercial lawyers, we see these risks time and time again. It's a real pattern. We often get people ringing us in that pain point. So, and we will have a free chat with them, and we'll try and refer them on to somebody who we know, like, and trust. What we do say, though, is that they do need to have a proactive thing to make sure this doesn't happen again. And we are finding that the people who are in pain are the people who haven't addressed those 5 things that we've just talked about. So let's talk about how you can prevent these things becoming an issue for you in your business. So first of all, probably the least sexy bit of this is your structure. So the structure is how you've set yourself up in business. So many people, when they first set up in business, or for example, if they do, you know, a new side hustle, you know, a new course or some new mentoring or training, they often just go and grab themselves an ABN. It's relatively simple structure that makes you a sole trader. So that's not unique to people who actually trade, you know, your tradies. That just means that you're not under a company structure. So, you know, the benefits from that are that it's relatively cheaper, but as your business grows, it is crucial that your business structure does evolve with it. So we always recommend in Australia that people set themselves up as a proprietary limited company. And it was the same in England with the LLCs. So I'm sure America's got, you know, similar sorts of structures. So the benefit of a company is that it is separate from you as a person. It's a separate legal entity. Whereas as a sole trader, you are personally liable for all your business debts. You can incur debt and you can be sued, which means your personal assets, so anything that you own, you know, your car, your house, any investment properties, etc., they're very much at risk from what you're doing over in your business venture. Whereas if you go to a company structure, that's a separate legal entity. which means that the company can be sued and sue, and that limits your personal liability. Now, there's a lot more to it than that, but if there's one thing that you take away from today, if you're a sole trader, is either give us a shout. If you're not in Australia, speak to your accountant or a lawyer in your local area, so we can help you restructure. The next risk, which I'll spend a bit more time talking about because it's a little bit more exciting, a little bit sexier, is we do see that people aren't protecting their valuable intellectual property properly. So, you know, I was saying before about this is the stuff from up here. This is the ideas, the processes, the systems, the how-to, everything that you're going to pull out of here and commoditize, which is what we do. And I'm sure that's what Sarah, you know, teaches you to do. You know, get it out, make it into a pack, sell it, make it into a course. That is your intellectual property. You can do that better than anybody. So you need to stop anybody else doing that.
This is a huge one. You know, I'm always saying to everyone here, we are the commodity in the industry that we are in. We are the educator, the facilitator, the course creator, the consultant, the coach. It is literally what's in our mind and how we teach what we teach, our IP frameworks that you guys create with me. This literally is your bread and butter. It is your commodity. And it's so important that you do the best you can to protect that. I've said to you a million times, we cannot control what other people do. We cannot control the goodness of other people or the inherently badness in the minority out there. However, when you have done things like trademarks and understand copyright and IP, if somebody does take it too far, you have a much stronger legal leg to stand on to enforce whatever enforcements you want to put in place to protect that intellectual property that may have been breached. Now, with the trademarking, this is actually, when I went and did this, blew my mind that this is a lot more simpler than in my head I had imagined it to be. And I had very sillily that's totally a word, put off applying for my trademark because I don't know why, in my head I expected it to be ridiculously expensive. I expected it to be almost impossible to translate, navigate and implement. And then you get someone like Helen and it's just fixed price, sorted, done, and absolutely limited labor on your part when it comes to this stuff. And I did literally just sit there and go, why have I put this off for so long? And we see horror stories. I don't know if any of you, I tell you guys to follow Facebook groups for entrepreneurs all the time because there's so much you can learn from them. But we see every single day people who have gone out there and been trading for years and years and years and years with their business, and they're in whatever industry they're in. Then somebody else who started a business yesterday files a trademark with that same name, and potentially, all circumstances are different, Helen, right? The person who's just filed a trademark has the potential to, claim that the rights to that trading name, and potentially the poor business that has been operating for many, many years may have to shut up shop or change all of their names in their Facebook pages. Now that's not it's not how it applies for everybody, obviously. Helen will tell you that, but this is why it's so important, guys. You know, what we think is, well, I've been doing this for ages, unfortunately isn't necessarily protection. So an hour of your time with somebody like Helen, or if in the US an attorney who does trademarking things, can save your entire business. It really could down the line if the worst happened. So I just wanted to jump in there because a lot of us go, I'm too small to need a trademark. Well, really what would happen if you are that small and what you do is your entire income, and somebody slapped a trademark breach on your desk and you had to close up shop? That's going to be devastating, quite literally, for you. So the little bit of investment and protection up front is going to save everything you're doing today in the future.
Yeah, it's fantastic, and I completely agree with you, Sarah. A lot of people put it in a too hard basket, and I actually think it comes from shows like Shark Tank, or in England Dragon's Den. And what happens is the dragons or the sharks will say, have you protected your IP? And then they produce what's called a patent, and then they talk about how it cost them 50,000 or it took 2 years. Now, that's not a trademark. A patent is something, to protect a widget that is very expensive, very complex. A trademark is literally getting your business name or your logo onto a public register with a sort of back off sign on it. So, and another thing as well is people do tend to confuse the fact that they've bought their business name. Here in Australia, you buy it from ASIC. They think that owning a business name is the same as registering a trademark. It's not. The only way to actually stop somebody else using your business name, and that could be a course name as well. It doesn't have to be your trading name. So if you come up with the idea for a course, for example, we've got Business Shield. So, Business Shield will be protected by trademark. And that's the name of, this protection tool that we've developed. But we trade as Rise Legal, and that is also trademarked. So registering business names as trademarks is something that you should do to protect your brand. And it actually protects the goodwill in that brand that you've protected. So if you can only register trademarks that are distinctive. You can't register, I always give the example of Gold Coast Gardener. It's descriptive of the services and the location. That will unlikely be trademarkable unless, you can prove some amazing goodwill in it. But registering your business name, if it is distinctive in your industry, so, Rise, you wouldn't think the word Rise is that distinctive, but in the law world, how many lawyers need to use the word Rise unless they're actually going to be copying our mark? So we have trademarked Rise Legal, which stops anybody using it in legal services. So you could stop Rise Law, Rise Lawyers, Rise Solicitors, so any derivative. We then went one step further and trademarked the word Rise so that it couldn't be used as like, Rise Advisors or just Rise, because a lot of people abbreviate everything here in Australia. So, people just call us Rise. So we've trademarked that. So just to give you some examples.
I'm going to just jump in with a question, Helen, that came up, is around the pricing of trademarks, which obviously varies massively depending on if it's just a name, if it's a name and a logo, if there's different categories that you want to trademark within. Can you, Helen, just give a little bit of advice around that? And obviously, I know that the absolute bare minimum for the lowest possible trademark that I've personally gone to look into has been a starting price of about 600 Australian dollars. I don't know if it's cheaper than that, but of course, then the more you add on, the more expensive your trademark application becomes based on how many categories and features and elements and industries that you want to be covered by. I'll let Helen expand on that.
Yeah, that's absolutely right. That's so you've got two costs involved. You've got the cost of registration with IP Australia here, and there'll be equivalents in every single country. And the registration costs here are $330. So this is as at May 24. They are $330 for a registration of one mark. So let's say your business name, let's take Rise Legal, in one class, in the legal services class. So if you wanted to put it in multiple classes, if you're selling merchandise, if you're doing education, training, courses, there's a great number. I think there's about 42 different classes of goods and services. We help with that though. It's daunting. It is very daunting, but we cut through all that and basically go, this is our advice. You need to register your business name in this class. And if your logo is really distinctive, so if you think about the golden arches of McDonald's, they're not going to want anyone using those. So things like that kind of imagery, if you've got some imagery that you want to protect, and you can do because you own the copyright, then we can protect that logo as well. But the best possible protection is to register the words. So, Rise or Rise Legal, because that protects it in any font, any color, any derivative, any logo. So no one can use it basically. The process takes up to 15 months. So, for a law firm to monitor that right from, the advice, giving you the advice on how to do it, and then monitoring it, dealing with any oppositions that might come in, because you can oppose somebody's trademark, dealing with all of that and then getting you on the register is about 15 months. So as at current date, I think fees usually sit around that $1,500 mark for, the lawyer, a trademark attorney to do that. So you can get packages where you do multiple for say 2,000 or 3,000. But that's kind of the fee. My understanding from business valuers is that it gives a value to your business. So it's definitely a tick point. It's definitely a capital asset to have a trademark, particularly when you come to sell a business. It's one of the questions we ask. So
Great.
we can definitely speak to anybody about trademarking. Just feel free. You'll have my details at the end of this. You'll have my details because if you've done that quiz, you may start getting some emails, just like Techmatics coming through. So you can definitely speak to us about trademarks. We love doing them, and we always have a celebration in the office when somebody gets a trademark registered.
It's so good. Thank you, Helen. We've got another really awesome question. And I know that this answer is going to be, it really depends on everyone's business. The question is, should we, as course creators, trademark every single course we create? Or is it more about trademarking our business and the kind of business we have? And I know that for every single unique person that you would talk to, you'd be asking us about the different income, where we're operating and trading those different courses and so on. For me, I've decided to trademark the Legends Lab, which Helen's helping me out with, because I don't want anyone else coming up with the Legends Lab, and that incorporates all of the courses that are within the Legends Lab. But Helen, can you just talk to us very generically around that, around should we trademark everything we create, every book we produce, every course we put together? Or, is that not necessary if we've trademarked our business and what we do?
Okay, so a couple of examples of that, and I'll come back to Rise Legal as an example. Obviously, that's the business, that's the main business, it's the law firm Rise Legal. So we've protected Rise Legal and Rise. So we can use that in any derivative. If we start doing accounting, we can do Rise Accounting, we can do Rise Advisory, Rise Conveyancing, all that kind of thing. And we have developed a course, the scorecard app that you did before, the Business Shield, we've developed that. So we're registering Business Shield as well, because we don't want people going out there and saying that they're offering a business shield, because no, we're offering a business shield. We've done that. We've got the business name, we've got the domain. When we speak to our clients, we do drill into where their main income comes from and the risk. So this is a lot of what the trademarks team will do with you on a strategy session, is to drill into the risks. So is there a real risk that if someone uses your course name, that you could lose income? So you can lose income in two ways. One is that people go looking for you, let's take Legends Lab, and they land on a competitor. And they actually end up, because that competitor can often do, a copycat website, make it look and feel. I've got one at the moment who's done this exact thing, that people land on it and firmly believe it's the business that they were looking for, it's the course they were looking for, and they end up signing up with that one and it's not the real one. So that's how you could lose some income. You could also lose income because generally copycats are not doing things to the quality and giving the service that the original party is doing. So there's dissatisfaction over here with the copycat. And then sometimes that can erode your goodwill in the industry, because people will take to Facebook, they'll take to social media, and they'll leave Google reviews, which might end up on your site, basically saying that that business is not delivering a very good service and it's not your business. So we've seen that as well. We've seen people who, have had complaints because of poor quality services provided by a copycat. So it is really something, if you're unsure, if you're completely unsure, then it's something you do need to put on your list. So today I'm hoping everyone's got a little pad and a pen. And, for example, if they were set up as a sole trader, they've marked on need to be company. And now they should have marked on, if they have a course name or a business name that isn't protected by trademark, they should have marked on trademark, exclamation mark. And, this could all form part of, next year's goals when you do your goal setting. That this, the legal have a section for legal strategy and protection. So yeah, it all depends on the value, in answer to your question, Sarah, the value that mark has to the business.
Awesome, thank you.
That's okay. All right, I'm just going to run through now. I've got a lot on client contracts. I know that was something you were particularly interested in, Sarah, for protecting, the biggest relationship that any business has is with their clients. So if we're drawing a line of risk, this would be one of the strongest lines of risk. This is where the most disputes happen. This is where the most tears fall and the most heartache happens. So just generally speaking, I do this presentation to rooms full of business owners generally. They could be tradies, they could be, medical practitioners, they could be, running shops and selling goods. So this to start with is quite general about what you generally need in your contracts with clients. And I didn't want to take this out because I have added some slides here for course creators and for people running retreats, just to give you an idea of what specifically needs to go in those terms. So if you already have terms, again, come back to this recording and go through your terms and make sure these things are in there. That said, if you already have terms and conditions and you're in Australia and you have not had them looked at by a law firm for, last year some new legislation came in. You may have seen it, and very, very boring. It's called the Unfair Contract Terms Act. It came in place in November last year, and it's now introduced penalties for certain unevenly weighted clauses in contracts. So if you haven't had your existing terms and conditions looked at, they need to be looked at, they need to be amended so you can avoid those penalties. So write that one down as well. We're happy to do, we've got a series of updates that we can do to anybody's terms relatively simply.
I love it. And can I just jump in a bit of contextualization there? Because a lot of people might think we're talking about, staff contracts and contracts to do with big projects. Guys, this can be as simple as you providing a done for you service. This can be as simple as you jumping on a 3-hour package call on Zoom with somebody to say, by the end of this call, I'll create a course outline for you. A lot of us will have clients that come in that thought they were getting this, and you've delivered what you thought you had promised, and then you have this, I want a refund, I didn't get what I thought I was getting. This is so important to have these really clear terms of agreement or terms of service in when you buy this offer, this consult, this project done for you service. This is what you're going to get. This are the specifics of the deliverables. This is the timeline it's going to take. This is why, all of us need to have one, but you do need to talk to a Helen to help break down what is it you are providing so that those conflicts and misunderstandings don't happen, and that you have a signed terms of service agreement to back you up if that person comes back and says, I didn't get what I thought I was going to get from you. And this, by the way, this terms of service that we're talking about here, or these contract agreements that you have with your customers, this is exactly what Helen's created for me. And that then, when you create an offer in Checkmatics and somebody clicks on your checkout to pay for that service, there's actually a checkbox you can turn on that says, I agree to the terms of service at the point at which they pay. That becomes another legal backup, because you've got the date stamped agreement in their client record to prove that that client did agree to these terms of service at the point at which they paid for the service, and there was a clickable link to the full service agreement outlines. This is how I protect my business via the help of Helen. So I just wanted to kind of bring that context back to your environment and how important this stuff is.
That's great. Thank you for that. Yeah, I think a lot of people think that a contract has to be this great big, scary thing like a builder would provide you when they're buying a house. It's not. Like Sarah said, it could be as simple as a tick box on your system. So when someone has signed up and ticked, yeah, I want the premium service, yeah, I want the 6 monthly plan, and then accept terms and conditions. So that's what I'm talking about. I'm talking about something that will get delivered to you as maybe a 6-page Word document that you can either upload into your software, your Techmatics software, or you could, if you are old school and you're sending out quotes, you're doing a Word document quotes or something, you can actually attach these as pages 2, 3, 4 onwards and have that as a PDF. Some people like that. Some people like to send them out by a DocuSign and get them signed. If you're setting up a 12-month program and you're going to be doing some training with a corporate will expect it a very different way. So again, we will strategize with you initially what you need, whether it's online terms, whether it's some form of services agreement, but essentially it is all the same thing. It is all terms and conditions. It's just how you present it. So those terms and conditions for any business owner really need to show how much you're going to be charging. What have they signed up for? What was the agreement on price? Because and the easiest way to make sure that you get paid is to have a really clear offer and acceptance with that set out really clearly what the payment was. A lot of people, I hang around in a lot of Facebook groups with small businesses, which is great because I can hear what's happening. I can see where the pain points are. Late payment at the moment. I don't know what it's like in the rest of the world. I'm assuming everybody's in a little bit of pain. People are not paying people. People are only paying for their power and for their electricity, and for their tax debts. That's top of the chain. Then their staff, so they can keep the doors open. Other people can be quite down the list. We want to make sure that you're high up that list. So for that, we need late payment terms. I will come to that in more detail. And we also need to limit your liability to make sure, in the example that Sarah gave, we thought we were getting this, we thought we were getting that. We need to be really clear what you're actually getting. And if you don't get the thing, what your liability is. And also there are legal requirements of things you can and cannot have in your terms and conditions. So there's rules on how much deposits you can take. There's rules on cancellation fees. We've got Australian consumer law here, which really protects the consumer over the small business owner. And, that unfair contract terms is a prime example of, even penalising the small business owner for having certain clauses in there. So, and we want to make sure as well for you guys that these contracts, so as well as protecting your IP with a trademark, that's to the world, oi world, don't use my name. We're also going to say to your clients, don't use this IP for anything other than what you've signed up for. So I'm going to drill into that in a little bit more detail. I know I'm going through this really quickly, but again, there's so much here and I didn't want to leave anything out. So you need to make sure. So you're either looking at this afresh, you don't have any terms and you need them, in which case we've got that amazing offer for course creators. If you're not a course creator, we have other amazing offers as well that you can reach out to us for. You need to make sure if you do have terms and conditions, they need to be looked at in relation to this and last year's legislation changes. They have to have what's called a deemed acceptance clause. A lot of people say, oh, so do we have to get them signed? Or, do we have to get acceptance by, the tick box online, things like that. What we need to do is make sure that there's lots of different ways in which it can be accepted. In certain industries, it's very common to pay deposits and deposits lock in contracts. It needs to be actually clear and written in the contract. If you pay a deposit, this is acceptance of our terms and conditions. So we put loads of fallbacks into a deemed acceptance clause. We don't see that very often when we source other people's terms and conditions, or ones that we see in templated ones online, which tend to be too basic for most people's needs. The price needs to be 100% clear. Sometimes we as lawyers, when people come to us and want us to give them advice on, late payment and how do I get paid, we weren't even clear when we look at the contract. What did you actually offer them by price? There's all these stage payments and 30% here and 20% here and 5% on delivery. And it's like, well, what was the price? That needs to be 100% clear. And that's one thing in Australian law, is that everything has to be in plain English, easy to understand, to actually form a proper contract. You do need, again, in those groups that I see a lot of, Google lawyers jumping in and saying, oh, just charge them interest. That'll make them think, or get the debt collectors on them. It's fine. The debt collectors will pass their fees on. Yes, if your contract allows that. Only if your contract allows that. If you do not have terms and conditions that give you a right under contract to charge interest, or to on-charge debt recovery fees, that is not something that you can then enforce against a client who never agreed to that at the beginning. Cancellation fees, you can't just willy-nilly charge someone a cancellation fee because you feel like it. It needs to be clearly set out in the contract that is accepted by the client. And it needs to comply with the Australian consumer law rules on deposits, in that it needs to be reasonable. So there are very strict rules on non-refundable deposits. Non-refundable deposits are only allowed when a buyer is aware of the fee prior to signing the contract, and it also should not be an unfair contract term. So it has to be, the general position I say to my clients is it has to be proportionate to their costs and time, and not penalise the buyer as being unfair. So you'd have to genuinely be able to say, I spent this amount of time on it, I bought these materials, I brought in a designer, I paid them this much. You'd have to be able to schedule out all your costs to be able to prove it hand on heart that it was reasonable and that it was proportionate to our costs and time.
Love it. Just on that deposit, Helen, we've had a really interesting question. What is the maximum percentage of a non-refundable deposit that you can charge in Australia? Is that different from business to business and service to service, or how does that usually work, or how is it calculated?
Yeah, so that's a really good question. It is different in each industry. So I'll give you an example. We do a lot of work with tradies. We love our tradies. And in Queensland, there's a percentage, depending on whether the work is above or below 3,300 or 20,000. There's percentages, either 10% or 5%. New South Wales has different rules for tradies. So there aren't as many rules outside of the building industry. But again, with the deposit, it's not the amount of deposit that you take that is generally regulated. It's the amount that you keep. So you could get a certain amount off somebody, but if they pull out an early level, you would have to, under Australian consumer law, be able to say that what you've kept from that deposit is in proportion to the amount of time and effort that you've spent on that client. So again, this is something that we don't sell templates, and we don't sell templates for a very good reason, in that everybody is unique, everybody is different, everybody does something differently. And we would want to talk about this with you as we customize your terms for you. We'd want to give you the guidance on what deposits you can take and what you can keep and when. Okay, so just running forward again, more things in terms and conditions. You think it'd be obvious, but how and when you can terminate. So an obvious one is breach. If there's a payment that's outstanding, but you do have to have that right in your contract. And I'm saying contract. Contract means terms and conditions. But we also throw some interesting ones in. So, for example, we throw in that we can terminate. So we, as the business owner, can terminate if we consider that a request for services is inappropriate, improper, or unlawful. So this will help get rid of the person who's asking you to do something that really doesn't sit well with your moral compass. And also we do put in things like, if for any reason outside your control, we're unable to perform those services within a required time frame. So if those time frames, to get a video course up and running for someone is just completely unrealistic, then we can terminate on that basis. And again, you'd need to speak to us at that time about what deposit you should and shouldn't return. We also want to make sure that our clients have no liability for delay. I know the world went mad a few years ago. I think we'll all remember that little virus that spread around, and we all had to stay at home for periods of time. It made some people very unwell. So, there were periods of time where people, service providers, providers of goods and services were unable to perform because of this. So a lot of people didn't have this clause in their contract, which is very well known, which is called force majeure. It's probably one of the only, non-English words that I ever use, but it basically says that we won't be liable for delay or failure to perform our obligations if a delay is due to a circumstance beyond our reasonable control. So we put that into all of our clients' terms and conditions. So that would be where you've just had no control over the delay at all. There's nothing that you could have done. We've had some awful weather in Australia. We've had floods. We've had, in Western Australia, we've had some awful fires. We've had all sorts of things thrown at us, acts of God, extreme weather. We need to prepare ourselves for those and make sure that we're not liable under contract if that happens. We also limit our liability at law. So what we want to do, I know America is slightly a lot different to what happens in Australia in terms of, I'll sue you for $5 million because that $10 call didn't go the way I wanted. It doesn't happen as much in Australia, thank goodness. But we do limit our liability in contracts. So it should be really limited to either you resupplying the services or refunding an amount that's been paid, less any reasonable costs. So again, that needs to comply with Australian consumer law. But the biggest thing that we really get involved with our clients on, and again, why something as important as this, your contract with your client cannot be templated, is we need to talk to you about your specific disclaimers. And one of the questions we ask you is what happens in your client relationship repeatedly where you're asked to do something or you're held responsible for something where you shouldn't have been. So one very good example of that is products or services that your clients may be directed by you to go and buy from a third party. If they have to go and sign up, if they have to use a certain videographer or anything like that, and then that's the issue, you do not want to be liable for that referral or for that third party. So these sorts of things come in, and I'm going to go through now course providers. So this is something that I threw in just for Sarah. Sarah messaged me last night. True Sarah style, I think about 8 o'clock last night. Can you make sure you cover? So I thought, yeah, absolutely fine. I'm the same as Sarah. I probably work to about midnight every day anyway. So I threw these in for you, Sarah. So these are basically when we provide terms and conditions for course creators, we actually want to ensure that there's clear clarity between the creators and their students. This manages their expectations, it protects the legal rights. And these are some of the key things that we would be, in addition to what I've been talking about before, which is the slab, that's the structure of your terms. This is very specific to course terms. Again, clearly defining what the course will offer, including the format. So this is one thing we've seen where people thought they were signing up for a live or people thought they were signing up for, you know, one-on-one face-to-faces, and it turned out to be, you know, videoed group sessions. So you need to make it really clear, the format, video, live sessions, downloadable content, what the scope is and any limitations to that. So both parties have got a clear understanding of what's being provided. This can differ. So one of the things Sarah asked is, can you use the same terms and conditions across multiple products? So again, when we have our initial scoping conversation with you, if you do have multiple services, we'll try and keep them more generic and then have your quote template, which is part one, so that it can be geared up around your different services. So your services need to be clearly put in. We leave that to you to put in your services. We can help guide you, but it could be that you can change that over time. Payment terms, payment method, you know, some clients may have thought that it was different. You know, it's just got to be clearly spelt out how and when they're going to pay, if there's direct debit authorities, getting the proper signatures. The refund and cancellation policy, I think this is where we see most course creators come unstuck, is, you know, wonder what circumstances must they provide a refund, what's the process, and, you know, what's the cancellation fees in relation to certain deadlines. So we find that having that set out at the beginning, you remember we were talking about the being proactive, doing it properly, having an actual clear prevention strategy will actually help avoid that really costly dispute down here, because it will be set out in plain English. You know, you get any idiot, go to you know, your idiot neighbour and say, what do you think this should have meant? And if they go, well, that means they were supposed to have paid this out on this day, and you go, well, it's obvious then. So that needs to be in there. The intellectual property rights. So clearly stating that you own that intellectual property and that you're only granting a license to your students. They don't own it because they've paid for your course. They can't take it, recreate it, repurpose it, and set up their own derivative of your course. Remember talking about copycats, and it's easier to copy somebody who's done something well than it is to start on your own. That's why franchises are so expensive and so popular, because you are basically duplicating and copying, but you do have the permission to do it. People try and do it dodgily. So we have a lot of course creators who do contact us, unfortunately, and say that their students have decided that they can do a better job, and go, and Sarah's nodding away there. And they've gone and copied it. And of course, you've given them all that beautiful material. You've shown them how to do it because you're a great course provider. So you've shown them how to do it. Well, we need to make sure that they can't use your material. So first of all, we need to make sure that they can't use your name of your course or anything similar because you've trademarked it. We need to make sure that your clients now can't use that content for anything other than it was licensed. And we need to be really careful about this license and prevent any unauthorized use. So user conduct responsibilities, so acceptable behaviour and obligations of the students, so to prevent plagiarism, ensuring respectful communication, particularly in a group environment. We want to maintain a positive and productive learning environment. I've been on I'm sure you've all got amazing stories, and I wish we were all hanging out around a table, but I've been in group mastermind scenarios where there's always one person. There's always the one person who loves the sound of their voice. They've got nothing useful to say. They've got nothing positive to say. They can actually be quite negative and judgmental towards people. You know, and I've actually almost found myself becoming head girl and taking them to one side and saying, you know, that's not helpful. But it'd be great if the course creator could actually do that legally and just say, you know, you're not creating a positive and productive learning environment, and we therefore need to remove you from the program, without you then being liable to that student for, you know, any loss or damage. Privacy is a huge one, privacy policies. So I think I mentioned right at the beginning, if you do that Business Shield quiz, and if you haven't had a chance, the link was in the chat, you do go into the draw in 24 hours time to win a pack, website terms of use and privacy policy. You do have to have a privacy policy at law. It's just something that every business owner who collects data has to have. You need to be clear how it's going to be used, how it's going to be collected, and how it's going to be protected. So we build that into your terms and conditions to make sure that you know, it's clear to your students that you are complying with Australian privacy principles. Again, I mentioned before about the disclaimers and limits of liability. So disclaiming anything that's outside of your control, such as technical difficulties. I'm sure some of us experience technical difficulties with our course, internet issues, software providers who decide, you know, that they're going to do some updates while we're running a webinar. those kind of things. So we just need to disclaim that so that it can help. And also a really specific one for course creators is disclaiming that the effectiveness of the course content, disclaim the effectiveness and state that results may vary for individuals. Now, sometimes we get people who do have a guarantee or a promise, and we need to word that very carefully. But other than that, what you get out is what you put in. And we need to make it really clear. You may not get the results that we've shown on our website from some of the other students because you may give 1% of effort with the materials we've given you compared to that person who gave 100%. So again, we need to put that in the contract that, you're not responsible for any specific results. Other stuff in there you can see, any amendments, you need to be flexible with your terms and how you can amend them if things do change, because we're all entrepreneurs, we're all ideas people. None of us want our wings clipped in terms of what we can do and how we can deliver it. That's why we've resonated to people like Sarah, because we're agile minds. We're not got fixed mindsets, so we want to make sure that our contracts haven't got a fixed mindset as well, so how we can amend those terms. And dispute resolution. So this is something that, I was talking before about how we're sat over here and scary dispute resolution lawyers, litigators are over here. They do not like dispute resolution clauses for the very reason that it takes a long time to get to them and to court, because a dispute resolution clause should be like a knocking two heads together. It should be that if there's a dispute between the parties first attempt to meet in good faith and resolve the dispute. If after 2 weeks they can't do it, then they should go to something called arbitration or mediation, which is like a mini efficient dispute resolution system where they can get somebody like, a representative from a local law society can actually come and mediate. WA has a really great small business mediation tool. When I was there many, many years ago, it was only $130 to appoint someone to help mediate a dispute. How great is that compared to the cost of over here? So anyone, if you're looking at your terms and you're going down these lists, make sure you've got a really effective dispute resolution clause. And also check your governing law. So the governing law of the contract should be the state that you are based in. We had someone the other day say, can we have a mutual state of Singapore? And I said to the client, do you want to fly to Singapore and hire a Singapore lawyer when you want to resolve a dispute, or do you want to do it here in Queensland? You're like, oh, is that what it means? Basically, it means which court are we going to hear these disputes in?
Yeah, that's really interesting. We did have a bit of a question from Susan, who's got a bit more of a unique situation, but based on this dispute resolution process, the generalized question would be, what would usually be the process for dispute resolution? Let's say we've seen a student copy our work, we've seen somebody copy or duplicate our work, we believe there's been a breach of our IP in some capacity. Obviously, I assume this comes down to, do we have a dispute resolution in our terms of service? What would be the process? I see that someone's copied all my blog posts and they're selling them over there, or they've copied one of my courses and they're selling it from their own platform. What does one do when we discover something like this?
Well, it's really, really key to control any emotion. I think that's the first thing. Just be very mindful, take the emotion out of it and become the business leader, become the CEO, not the person. Then call your trusted lawyer. So whoever's prepared your contract for you, whoever you know, like and trust, obviously we would love to become that person for all of you. You call us and you let us know what's happened. We get some details, and then usually the first point of call would be for me to say, well, were they a student, Sarah? Were they one of your students? Yes. Okay. Can you show me the contract that they signed? Can I see either the terms that they accepted? I need from your internet provider to see that they actually did accept them. So then I know that they've signed them in the electronic version. And then I need to see if there's a dispute resolution clause, and then we would follow that. So we would most likely serve what we call some form of cease and desist. And we would say to them, you must immediately cease and desist using our license materials. You're in breach of this license. Under the dispute resolution procedures, if you feel that this is a dispute between the parties, we need to meet in accordance with this clause. If you don't meet with us, we will appoint a law society representative to mediate this. Now, often this is where disagreements arise. Now, that can be distinct to an actual breach. An actual breach, which is clear, they've taken your material, they've used them outside of the license, that is a breach. That one we can go straight in, go straight hard, and we can cease and desist them and say, if you do not stop, you need to immediately, we find out from the client, what do you want? You want it all removed off the website. You want it removed off their social media. You want, I don't know, some people say I want an apology. I think that's probably the emotional side coming in. Some people say I want a public acknowledgement. Again, someone wouldn't defame themselves in that way. So we just try and keep it quite simple. Like, what's the simplest thing you want? You want them to stop it. Basically, they need a letter that just says stop it, exclamation mark. So we'll send them a stop it. If they firmly believe that you've misled them and you sold them a course and they thought they were buying the materials for their own use, then it could become a dispute.
That's awesome. Thank you, Helen.
It's okay. This is where we actually bring in colleagues of ours who we know, like, and trust, who do dispute resolution. So it doesn't happen very often, and mostly for people who call us who didn't have our terms in place. So, okay, I'm going to move on to retreats. So retreats obviously very, very different because there's an actual interactive and on-site activity, which is obviously going to be more dangerous than an online course. So there's several other things that we put in that are crucial to protect you as a business. So one of the things that's quite rife for me with something that's happening with my mum at the moment is clearly describing the type of accommodation and amenities that someone's going to get, in particular, whether there's any limitations or rules regarding the use of those facilities, but also in particular whether that person has signed up for a sole or a dual occupancy. So that's exactly what's happening with my mum with one of her old lady bus tours at the moment. Health and safety, we need to outline health and safety protocols that all our participants must follow, especially if the retreat involves physical activities or if it's located in remote areas. That can be as dangerous as physical activity for someone who needs medical attention. They need medical disclosures. Participants need to be aware of their own responsibilities to manage their own health needs. Bring your own insulin, that kind of thing. It needs to be spelt out. If travel is included, who's responsible for booking and managing travel arrangements, or if participants must manage their own travel. We've seen this before where people have signed up for a retreat and not realised that there was no flight included to get them from WA to New South Wales. So again, we just need to spell it out. It's basically, you just got to put it all in writing as though, you're dealing with somebody who hasn't, it's the small print. It basically is the small print. Just put it all in there. Include terms about changes to travel plans, any associated fees, liability waivers, make sure that they comply with local laws. So this is something else, sometimes we have like maybe a Queensland client who doesn't realise that if they're going to start doing some trekking trips in Broome, that they need to comply with the local laws in Broome, and not the retreat terms that were prepared for them for Queensland will need tweaking. We need to disclaim liability. We can't always disclaim liability for negligence. If you've been negligent, no terms in the world will be able to help you. But other than that, you need to be able to have good liability waivers. Again, the cancellation here is going to be even more rife because, it could be cancelled by the owner, the people running the retreat. You might not be running it, you're just facilitating it. If there's insufficient participants, if there's a natural disaster, if there's unforeseen events, what the process is then for issuing either refunds or credits. The participant behaviour, we were talking before about, people being well behaved, particularly you need to have rules against harassment or other illegal activities. Some people go to these retreats thinking that it'd be a great chance to let the hair down. If you don't understand what I'm saying, you might not want those illegal activities happening on your retreats. If they've got any special dietary, physical, or accessibility needs, we need to know about those. And insurance is a big one. This is a huge one. Who is insuring the participants? They need their own travel insurance. Do they need medical or personal liability insurance? And do you need that? So we work very closely with some amazing insurers, and we will help our clients deal with the insurers to make sure that they've got the right insurance and are requesting their clients to have the right insurance. Photo and video release. Everybody loves to, post photos. And the usual stuff that we're talking about before. So, making sure that everything's confidential, what goes on tour stays on tour, that kind of thing. So that's it for retreat terms. Now I do have a couple of other slides, but I can see from the little clock that's going in my top left-hand corner that it's 11:02. And I don't know whether Sarah's one of these that gives an extra 5 minutes or whether she wants to get people off to work.
Well, if there's more questions, and there have been more questions come through, and people would like to stay on. Obviously, I'm very aware of your time as well, Helen. I know you've got lots of busy work to do, but I'm very happy for us to stay on a tiny bit longer if Helen that suits your schedule.
Oh, that's absolutely fine. That's
Yeah,
perfect for me.
awesome. I was going to jump in and ask again, just for opening this conversation up a bit more. Not everyone at the moment is running treats. I know a lot of people are planning to, so this is really, really timely information. But we do have members in the community here who certainly are planning to be running in-person workshops,
Mhm.
conferences or boot camps. So, for example, I've got my Legends Lab live boot camp coming up, which is a 2-day event held in a professional conference venue. I assume that what you've got here around the retreat would be very, very similar terms of agreement or terms of service agreements that all our ticket holders would have to buy. So just for those people planning workshops, can you just give a little bit of advice around that as well?
Yeah, absolutely. So a lot of this stuff would come into play if we go through the list. You know, the photo and video release of the participants, you'd need to get that released. We'd need to make sure that if we do have any special physical accessibility needs for people, that they're.
Oh, Helen's just dropped out there. Well, she's just frozen for a second, guys. Just to add in, these kinds of agreements can be done in your Techmatics forms. So obviously you need to talk to somebody like Helen or an attorney locally, the country that you're in, to find out what things need to be in that agreement. But some of the ways I've done this with in-person events, with like the photo release forms, i.e. I agree to be in photographs that can be used commercially, publicly and otherwise. That can be check boxes in Techmatics forms. So when somebody checks those boxes and then signs the signature box, because you can add a signature element onto Techmatics forms, that is, again, a record of agreement to those terms of service. So you don't have to be physically printing out these documents and handing them around the room on the day, right? Some of these elements, you can take what your lawyer or Helen or anyone has prepared for you and then digitize that so that you can, make it automated, that when X person buys this ticket to this workshop, then in the automation, now send this form, and then add a go-to repeating cycle that will then keep on reminding them to fill that form in every 24 hours until the form has been filled in and submitted. So I'm just adding an extra element there where we lost you for a second, Helen.
I didn't realize I'd been lost. I was talking and then I could see you talking and I thought, oh, that's really nice.
Yeah, no, we lost you for a second. We
That's
lost
okay.
you where you said it would depend on what you're running, but we didn't actually hear anything
Yeah.
else.
Okay. So I just literally went through that list and said it's very, very similar. You just take the sort of physical aspect out of it and the accommodation aspect, but we're still talking about cancellation. That's going to be the biggest thing, is how and when people can cancel. Making sure that people are if they've got special dietary, physical, or accessibility requirements, that they do let you know that, and we fill in disclaimers and things like that, just like you were saying. So yeah, we would definitely deal with all of those when we do your workshop and conference terms. We've done a really interesting one for somebody who wanted, at the end of their workshop, somebody to walk towards the sword, the sword to the neck. So I know some conferences like Tony Robbins ends with the hot coals. Another conference we've been helping somebody with that walks towards the neck. We've also helped particular conference owners with their affiliate arrangement with their speakers. So again, this is getting wider now. I'm probably talking more about the people we partner with, which is what I'm going to come to really quickly. So you do need agreements. I'll just run through this really quickly. You need agreements with all the people you work with. So we've done you and your client as being a relationship. Now you need to think about what other relationships you have in the pipeline. Obviously, staff need an employment contract, but people who aren't staff, people who are contractors, who are coming to you on an hourly rate, they need a contract. They could still do things that could damage your business. They've got access to your IP. They've also got access to your clients. So we need to make sure that they're not going to steal your clients or your staff. There was a period of time where staff were like gold dust. I don't think it's as bad anymore, but people stealing staff was huge. It was worse than stealing clients. I've put affiliates in here as well, because I think we do work very closely with our affiliates and make sure that we're doing co-marketing and that we're co-branding and things like that. And it's a very lucrative relationship. And I'd say that you work with them, whether we partner with them or work with them, you need a really good affiliate agreement, and we can help with that. And then just business partners. So one thing I want to mention is some people do rush into starting a business with a friend or a family member, and they don't think about what might happen if something goes wrong. There is a really simple fix. If you do set up a company, we want a document called a shareholders agreement. And that documents, you know, how and when decisions are going to be made, what happens if there's a deadlock in decision making, those dispute resolution clauses that I mentioned that are so important to go in any contract, but particularly how and when you can transfer your shares. So we get a lot of people calling us saying, you know, we want to leave, can we just sell our shares to a third party? So, you know, without the rules on it, there's really no rules. So we want to make sure that there are rules on how and the value for those shares so that no one tries to pay you $1 for them when it's a $5 million business. So again, if you're in partnership with anybody, even if it is your life partner as well, you really do need a shareholders agreement, because the courts are full at the moment of people arguing with what they thought should happen when a particular event arises. That should be written in a rule book and in the bottom drawer ready to be looked at. So that's it. That's a really quick whistle stop tour of those 5 risks, the things you can do to prevent your structure, your intellectual property, your relationships with your clients, your suppliers, or your business partners from basically derailing all the good stuff that you've done. And this is the offer. This is what Sarah popped in the chat box. There's a Q code there if you want to go on. And for 24 hours, we've made this less than half price, a ridiculous price. The team shouted at me when I came in this morning, but just for 24 hours for you guys, we really want to get you in and get you these terms. If you are wanting workshop terms, conference terms, if you are doing something slightly different, then just email us or just, you know, find us online. You can book a free call in on the website and just speak to us, and we'll let you know what you need, and we'll package up a really great deal because you've come through. Just mention Sarah Cordiner and we'll package it up for you.
That's absolutely amazing. Obviously, I've worked with you for every time I talk to Helen. There's very few people in the world that when I talk to you, I learn loads of stuff, but I always do with you. There was a couple of questions that I said I would come back to if there was time at the end. So I'm just going to run through those questions that popped up. So the first one that popped up around intellectual property, Helen, was we've got from one of our members here who sells music. She creates music, she sells music that she creates and indeed that her students create. Do you deal with arts law and arts-based related questions? Do you do licensing of music, licensing of artwork and things like that?
Absolutely, yeah. And this is one that we would actually partner with somebody on. We've got a really great trademark and licensing attorney that we partner with. So they would do a certain element, we would do a certain element, but you would deal with us directly. The licensing is something that I'm very all over, because I do a lot of franchise law as well, which comes into play with all this IP licensing, etc. So yeah, we'd love to have a chat with you about how we can help you. If you're unsure about anything and it's legal, just give us a shout, because if we can't help you, we will point you in the direction of somebody who can. We've got a really great network of fabulous lawyers that we know, like, and trust.
Thank you. There's another question that probably can't be answered in this forum because it's a very unique question, but it's just around cancellation fees, and in particular where physical products and stock are involved. The question itself was, what's the maximum restocking fee that you can legally charge when a customer returns a product? Obviously, I imagine that's going to have loads of it depends around it. Any sort of generalized advice on that?
So if, for example, this was a non-regulated product in Queensland, for example, let's take, for example, cat collars. So it's not medical, it's not perishable, it can be returned. So it just have to be then the cost of delivery, essentially, and the cost of whatever your business has outlaid in order to get that to the person. But this all comes down to what should have been told to them at the beginning. So if you remember, Australian consumer law only allows you to keep a non-refundable deposit if you have spelt that out to them. And this would kind of sit with that, because, and again, it comes down to why they've returned it and how they've returned it. Because we've had clients who'd ordered things before Christmas and then weren't delivered them until February. So obviously they'd wanted them as Christmas presents. So each is a circumstance that we need to do. But this is something that we would put in your terms and conditions to spell out very clearly, when this happens, this is it. And we would add a restocking fee. For that, might be a percentage of the amount paid, or it might be a fixed amount. And we'll make sure that that complies with your relevant legislation.
Awesome. I guess that would be a similar answer to the next question, which was around the force majeure situation, which is obviously when something that we can't control impacts our ability to deliver upon a product or service. The question asked was, does that apply the other way around? So, for example, and I'll give you one of my real life examples to context this. I help people create their courses and get them published. Now, obviously, if my house burned down or something terrible happened and I couldn't fulfill that project, that's where the force majeure contract terms, whatever, would come in. However, if it's the other way around, there is a phase in my delivery in providing these services where I then have to wait for the client to do stuff too, like go and do their filming of their videos. And I can't complete the project until the client sent me the stuff they need to send me. Is there like an opposite of a force majeure?
Mhm.
Like, so if my client has delayed the delivery of this project for so long, that is there a way we can cancel it? What happens in situations like that?
Absolutely, that's a fabulous question. So that comes in a few places. So in answer to your question, there would be a no liability for delay where the response or information is your responsibility. So that would come in. So you, Sarah Cordiner, have no responsibility for the delay of your obligations because the delay was caused by their inability to give you the information or materials that you needed to progress. So that helps you. There would also be termination for breach, and the breach there would be a client obligation, a specific client obligation to provide information in a timely manner. Or to, we can even drill into that, to meet I do a franchise program with someone, and there's very strict timelines for moving through each part of the program. And we're very strict that when they get to section 2 of the program, you need to return your questionnaires within 14 days. So again, just making it really, really clear what would constitute, because without all of that stuff, so if you've just got a Stripe link online, someone's paid online for your course, and you don't have the terms and conditions with all this stuff in, you wouldn't be able to do any of this stuff. You would be in breach.
Absolutely, that's awesome. And I don't think there is any left that we haven't answered. So I'm just scrolling down, so bear with me 1 second. So Sharon's asked a question that again would be related to intellectual property and probably slightly more than that. Sharon has physical aromatherapy products. So in terms of like, would it be a trademark? Would it be a patent? When it comes to kind of, she makes her own natural remedies, so to speak. What kinds of processes people making products like that? We've got people make candles, people make oils, people make face creams. Would you be going for patents? Would you be going for trademarks? What kind of things do you need to consider?
Okay, that's a really great question. So first of all, if the name is something where people would go in and look online to buy this particular product, the natural remedy, if the name is something that you want to make sure no one else can copy and use, then you need to trademark the name of it. If we're looking at either the recipe or the way in which it's put together, then that could either be a design right or a patent, but we'd need to talk to a patent attorney about that. Probably not. I would probably say that the best way to protect that is keep it in a locked safe, the way in which you do it, and make sure that the only people who have access to the how-to are either a very trusted employee on an employment contract with non-competes in there, or a trusted contractor on a contractor's agreement with non-compete. The suppliers are usually your worst enemy there. So if somebody else is manufacturing or supplying it for you, they are the people with the exact knowledge and know how to get that out to market. They could get that straight to Coles, Woolworths, Priceline, that kind of thing. So there's lots of different, we've got a whiteboard behind me here I could have drawn on there. There's lots of different risks coming in at you for somebody stealing that. And basically it's anyone who gets hold of it. If it's like grandma's recipe written on a piece of paper, anyone who's seen that is a risk to you. That's where your risks lie. But we'd love to have a chat with you about that, Sharon. We can sort of give you a little plan of action. There's a lot to take in here.
Yeah.
A lot
And
to
just to
take
let you
in.
guys know, Helen does do free 15-minute quick chats. So if kind of you've got a few of these questions that really are related to your unique situation, do scan Helen's QR code on the screen here and book in a 15-minute call with her, because in that call she'll be able to give you a really good idea of the main urgent things you need that are your really, really high risk things, and then she can give you a fixed price to help you fix those holes very quickly. So that's exactly what she did for me. We just sat down and went, this is what I do, here are the things I work on, and she went, right, these are your biggest risk areas, these are your biggest things that could really put you in trouble if something went wrong here. And we worked on those things first. Fixed price, this is what it's going to cost you, Sarah, to fix these things. And then we've got a whole plan of action for the next 12 months of all the things we're going to keep building, doing and actioning together. I've got another question here, Helen, from Trisha. We've got a lot of people on the call who are from the US and from the UK. So obviously they might want to take what they've learned from you today and find a local attorney or lawyer in those places. But they're asking for the kinds of stuff that you help in business protection, things you've talked about today. Who should I look for if I'm in the US or the UK? Am I specifically looking for an IP attorney, a general attorney? Can you give some advice around who they should find the equivalent of Helen to in one of their country?
The UK is easy because I have practiced in the UK and I'm qualified in the UK. So again, you're looking for what's called a commercial lawyer. So either a business lawyer or a commercial lawyer. And then what you'd want to do is just look on their website and make sure that the whole focus isn't around, you remember, they're going to court and the fighting and we'll represent you, we'll win your case. If you see that, just get straight off that website, because that is not going to give you the protection you need, because they like to fight. Keep looking until you find someone who is basically talking about protect your business and talking about client agreements. Maybe Google commercial lawyer, you don't need to be your area, but UK client agreement. We know some great ones. Again, we've got a great network like that. And they should do the IP protection. If not, they'll know someone to help. So they're the best gatekeeper for you. They're like the accountant. The accountant might need someone else, but they'll do most of it. In the US, I guess it's the same thing. It'll be a commercial attorney. I wouldn't start looking for IP, because unless any of you have developed a widget or a product that cannot be copied, and you've done something so unique that the world will end if someone copies it, that's a patent. I'd just be really careful about spending a lot of money on patents like that when there's a lot of other ways you can protect your IP.
Yeah, fantastic. Well, I think, Helen, I know that you've got another meeting to get on, and so have I today. So I'm going to time us out there at that particular point. Would like to say a huge thank you to you, Helen, for giving up your time for us today. I think we've all learned lots of new things. Hands up, we've got lots of food for thought about things that we need to do. As I've said, I've dropped another link back in the chat there, guys, with a really special offer that Helen's put together for you for terms and conditions package that is really tailored around course creators, coaches, consultants. So do go and check that out. It will take you to Helen's website. As I said, she does have a free 15-minute call if you actually want to go and have a chat with her and ask any questions, or you can send her an email directly. She is amazing, hence I've picked her and I love working with her. Helen, thank you very much for your generosity today. It's been amazing. Appreciate it.
It's been great. Thank you for having me, everyone.
Thank you. See you guys. Thank you. Bye.